Jim Farley did help Bates and Meyer take control of GAC. Peck was forced out and his stock was redeemed. After they took control of GAC, Bates and Meyer introduced their new software program. It was wildly successful. Within a few weeks, they had hundreds of orders. GAC's net worth soon increased from less than $500,000 to over $20 million. Shortly thereafter, George Peck sued Bates and Meyer for breach of contract and breach of fiduciary duty. He also filed a separate lawsuit against Jim Farley and Martin and Paul for legal malpractice and breach of fiduciary duty. Peck claimed that he was Farley's individual client and that Farley breached his fiduciary duty to him when he helped Bates and Meyer take over the company. Peck sought $8 million in actual damages and $8 million in punitive damages for a total of $16 million. At trial, on direct examination, Farley testified that he had never represented Peck individually and had never done anything to make Peck think that he did. Farley was cross-examined on those points by Peck's lawyer, Michelle Hardy, an experienced plaintiff's legal malpractice lawyer.
In your direct testimony, Mr. Farley, you claimed that you never represented George Peck individually. Isn't that true?
That's true. My only client was GAC. I never represented George.
But Mr. Peck was responsible for paying GAC's legal fees, wasn't he?
No, GAC paid our fees.
I didn't ask you who paid your fees, Mr. Farley. I asked you whether Mr. Peck was responsible for paying your fees if GAC didn't do so. And Mr. Peck was responsible, wasn't he?
Well, yes, but that clause was just a standard part of our engagement letter for startups.
Well, was he or was he not responsible for your fees if GAC did not pay them?
Yes, he was.
Now, in 2005 and 2006, you frequently gave legal advice to Mr. Peck, didn't you?
Sure, I gave him legal advice about GAC. He was the CEO.
How often did you give legal advice to Mr. Peck? Between January of 2005, when you first met him, and June of 2006, when he ceased to be CEO of GAC?
I'd say on average once or twice a month.
And how often did you have face-to-face meetings with Mr. Peck in that time period?
At the beginning, maybe once a month, a little less after that.
In some of these telephone contacts and meetings, you advised Mr. Peck on his personal relationship with GAC, didn't you?
Well, no. I just advised him as CEO of GAC.
Mr. Farley, in February of 2005, didn't you meet with Mr. Peck and discuss the GAC shareholders agreement?
Yes, I think it was February.
And you met with him separately, without Mr. Bates or Mr. Meyer present. Isn't that true?
Yes, I had some other business to talk with George about, and Brian and Justin were out, so I met with George.
And in that meeting, you advised Mr. Peck about his individual rights and duties under the shareholders agreement, right?
Well, yes, but that was my job as GAC's lawyer. But I didn't tell George I was representing him.
Did you tell Mr. Peck that you weren't representing him?
It didn't seem necessary. I'd already told him I was only representing GAC in the engagement letter.
So it didn't seem necessary. But later that year, in November 2005, you had a telephone conversation with Mr. Peck about his rights and duties under the shareholder agreement, didn't you?
Yes, George was thinking of cashing out some of his investments in GAC, and he asked me how he could do that.
And you again advised him about his rights under the shareholders agreement, correct?
Right.
On that occasion, Mr. Farley, did you tell Mr. Peck that you were representing only GAC and not representing him individually?
I don't remember.
But you knew Mr. Peck would rely on your advice to make some very important financial and personal decisions, didn't you?
I guess so.
Now, would it have been a good thing for GAC if George Peck had withdrawn his investment in the company in November 2005?
Things were a little tight financially for GAC then. It probably wouldn't have been the best thing for GAC if George had cashed out part of his investment.
So it would be fair to say that GAC's interests and Mr. Peck's interests were not the same on this issue, right?
Well, I never thought of it that way.
Mr. Farley, you're familiar with the rules of professional conduct for lawyers in our state, aren't you?
The ethics rules? Yes, I'm familiar with them.
Are you aware of any ethics rule that applies when you represent a company like GAC and you consult with a company officer on a matter where their interests may be adverse?
I'm not sure what you mean.
You might want to check Rules 1.7 and 1.13, Mr. Farley, which required you to explain that your client was GAC, not Mr. Peck, when you realized their interests were adverse.
Objection. Ms. Hardy is testifying and arguing with the witness.
Withdrawn, Your Honor. When you met with Mr. Peck in February and talked with him in November, did you tell him you had a conflict of interest in advising him individually about the shareholder agreement?
No, I didn't.
In those conversations, did you tell Mr. Peck that you couldn't represent him and that he might wish to obtain independent representation?
No, I didn't do that either.
Finally, Mr. Farley, did you tell Mr. Peck that your advice to him might not be privileged because you were not his lawyer?
No, I'm afraid I didn't do that.
No further questions, Your Honor.
After Jim Farley's cross-examination, he and Martin & Paul's managing partner met with the firm's defense counsel and malpractice carrier. They quickly decided to make a settlement offer to George Peck. Peck's claim against Farley and the firm settled for $3 million. The firm's self-insured retention was $1 million.